On the 24th of September 2019, the Supreme Court of the United Kingdom declared that Boris Johnson's decision to prorogue Parliament for 5 weeks was unlawful, and since then there has been a lot of talk about how Boris Johnson broke the law. But is that actually what unlawful means in the judicial review sense? I will briefly explain this with an emphasis on brief. There are essentially three grounds on which a decision will be declared to have been unlawful, and those are irrationality, illegality, and procedural impropriety / breach of natural justice. Breaching legitimate expectations or promises by public bodies is also a ground for judicial review, but we're not going to go into that today. According to Lord Diplock, an irrational decision is one that is so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question could have arrived at it. Irrational decisions take into account irrelevant or improper factors and or fail to take into account material considerations and or no reasonable person could have arrived at the decision in question. So, a brief example of an irrational decision would be the head of a building authority refusing a development application because the developer imports whiskey from France rather than Scotland or Ireland. A procedural impropriety is essentially where a decision maker fails to follow the processes for making decisions that have been laid out in either a relevant piece of legislation or common law. In such cases, the decisions are often declared to be unlawful. Equally, where the rules of natural justice apply, any breach of them will result in the decision being declared unlawful. Essentially, the rules of natural justice require that a person that will be affected by a decision is afforded a fair opportunity to be heard, and where a decision will have an adverse effect on a person, then they have the right to know the reasons for that decision. Illegality just generally means that the decision maker has exceeded their authority, that is to say, they have acted ultra vires or unlawfully. It doesn't therefore necessarily follow that the decision maker has indeed broken the law in the traditional sense, although that is a possibility. Rather, it's really a statement saying that the holder of a public office or a public body or authority made a decision which they had no authority to make, such as, let's say, a building authority purporting to grant a person a license for the operation of an insurance business. Clearly, the building authority would have no power to grant such a license. In the Boris Johnson prorogation matter, the court was essentially looking at the limits of the power of the Prime Minister to prorogue Parliament. And they found that while it is true and indisputable that a Prime Minister has the power to prorogue Parliament, they cannot do so if it will prevent Parliament from carrying out its functions. And if a prorogation will be for an extended period of time, the Prime Minister has an obligation to provide a proper and reasonable reason as to why. The Supreme Court found that the effect of Boris Johnson's prorogation of Parliament was that it would have prevented Parliament from carrying out its functions in overseeing the governance of the country, and further, that he provided no reason as to why prorogation would have went on for 5 weeks, which is indeed a very extended period of time. Consequently, they held that Boris Johnson exceeded his authority and therefore acted unlawfully in advising the Queen to prorogue Parliament. Thank you for watching. If you enjoyed this video, please leave a like below. If you have any comments, I look forward to seeing them.